Good afternoon, everyone. It's Ann Bell here from Ontario Nature. Thank you for joining us for this webinar on the review of the ESA. Our objectives in hosting this webinar are first, to raise awareness about the ESA and what is at stake, and second, to encourage and support informed public engagement in the review. The three of us who are presenting today, Rachel, Justina, and I, care deeply about the outcomes of this consultation. We've been involved with the ESA for over a decade, advocating for its creation prior to 2007 and supporting its implementation through research, education, and advocacy ever since. I'll begin by providing a brief overview to set the context. Justina Ray from Wildlife Conservation Society Canada will then look more in depth at potential changes to the law. Then Rachel Plotkin from the David Suzuki Foundation will outline the opportunities for participation in the review and resources that collectively we have to offer. After that will be an opportunity to ask questions and open up the discussion. As most of you likely know, the Ministry of Environment, Conservation and Parks has now taken over the administration of the ESA. It announced the review of the ESA in January and posted a discussion paper on the Environmental Registry. It is seeking comments on this discussion paper up until and including March the 4th. The stated objectives of this review are to improve protections for species at risk, to consider modern and innovative approaches to achieve positive outcomes for species at risk, and to look for ways to streamline approvals and provide clarity to support economic development. In our view, it is the first objective that needs to be the overriding objective, the objective against which all changes are to be measured. Options for consideration which do not support this first objective should not go forward. Unfortunately, the overall direction of the proposed options is environmental deregulation. They are about making it easier and faster for industry and development proponents to proceed with activities that harm species at risk and their habitats. Despite reassuring words that the ministry wants to improve protections, there's precious little in the discussion paper to support this assertion. The options for consideration include introducing ministerial discretion about whether threatened and endangered species and their habitats will be protected, introducing a process to second-guess the science-based listing decisions of CSIRO, simplifying requirements for permits and exemptions to undertake harmful activities, and extending or removing legislated timelines for planning and reporting. This does not sound like improving protections for species at risk to me. On the contrary, this sounds like an attempt to undermine the cornerstones of the legislation: automatic protection for endangered and threatened species and their habitats, science-based listing, and mandatory timelines for planning and reporting. Consider the way that MECP has framed the review in the discussion paper, characterizing the ESA as administratively burdensome and a law that creates barriers to economic development. In the context of the government's broader open for business agenda, this looks very much like another effort to cut red tape. I think collectively, we need to remind the government that this is the Endangered Species Act, not the Endangered Business Act. The purpose is to protect and recover species at risk. Is MECP, as the ministry in charge, committed to achieving this purpose? If so, then it's time for the ministry to uphold the original vision of the law, which included a significant focus on recovery and habitat protection. Endangered species need more than lip service, and so long as the focus of implementation is finding quicker, easier ways to authorize harmful activities, species will suffer and continue to decline. It's that simple. Failures to date are failures of implementation, not of the law itself. There are two key points we'd like you to remember when reviewing the discussion paper. First, there's a fundamental difference between revising the law and improving its implementation. For the most part, the challenges described in the discussion paper are implementation issues. Amendments to the law are unnecessary to address them. Second, the activities referred to throughout the paper are by and large harmful activities. They are activities prohibited by the ESA. For example, killing or harming members of threatened or endangered species, or damaging or destroying their habitats. Simplifying authorizations means making it easier for these harmful activities to occur. Be careful if you choose to comment on the discussion paper. Some of the suggested changes that might sound reasonable are actually already covered in the ESA. This includes, for example, landscape level planning, flexibility to review CASERO decisions based on credible science, flexibility for economic activity, flexibility to delay or not proceed with the habitat regulation, and a framework to harmonize ESA requirements with other legislative or regulatory frameworks. Legislative changes are not needed to accomplish these things because they're already in the law. The problem is implementation. There are many challenges outlined in the discussion paper, and such as inadequate notification of species listing, meeting deadlines for planning and reporting, and unreasonable delays in issuing authorizations. But these can and should be addressed through better planning, implementation, and investment in communications, program development, and staffing. So the bottom line in our view is that the law doesn't need to be changed. To address the challenges, improve implementation of the law. The question you'll need to ask yourself in responding to the discussion paper is whether the government is serious about providing more stringent protections for species at risk. I think you know what our answer is, and Justina's presentation, which is next, will explain why.
Okay, so I'm going to start out with just an overview of the report, and then I'm going to dive into a few of the sections. And my purpose here is to just give a bit of a kind of an analysis of what is being considered and what the challenges are. And so first, just to, the report itself is only about 7 pages long, so it's pretty short. It starts out with an introduction that gives us this overview of what the purpose of the exercise is, and then it delves into 4 areas of focus. And with each of these, it talks about challenges and then discussion questions, one after the other. So nothing is explicitly recommended or proposed, but questions are asked which kind of are floating some ideas in response to challenges that are articulated. Because it's such a brief paper, there's no analysis of the challenges, there's no discussion of where the challenges come from, but sort of presented as such. And the other important thing to kind of frame this with is that at the introduction, as Anne talked about already, the government really talks about its commitment to ensuring protections for species at risk, including the using the word stringent. But then as you get deeper into the paper, the welfare of species is fairly absent in the discussion paper, and it really focuses on enabling development. And so any mention of species really comes in companionship with enabling development. So both objectives are really being sought after here, but particularly from the enabling development perspective. So I'm going to go into each one of these area of focus, and the first one is called landscape approaches. And the first is like what is revealed by the challenge and discussion questions. They're really, without even having to read the paper, the main issues are there's concerns about the process for getting through the many steps in the Act. So there are many species, obviously listed over 200, and with each one has to go through stepwise process to get to recovery actions. And so if you're doing each one of these independently, then obviously this is a significant process getting through many of the steps of the Act. So that's one challenge that is presented. And what is also revealed is that there really is an interest in, or perhaps intention to replace species-specific measures in the Act with a landscape approach, which it doesn't really explain what it is. And the reason that we know that it's looking at replacing or is because it says very explicitly that this landscape approach would be brought in instead of a case-by-case approach. And so what might that mean? Our response to that is that, of course, the process of assessing and recovering species is incredibly complex and getting increasingly so with each new species that gets added to the list. This is a very difficult job getting from the listing to recovery strategies and government response statements, let alone actions. And at the same time, authorizations are going on. So it is a very, very complex situation, and that is absolutely the case. But also another important point is that MNRF at least has been considering these kind of landscape approaches for many years and implementing them in some fashion, usually in the name of finding efficiency. So there was a proposal a few years ago for this, and ecologically speaking, this is also not a new concept. So the notion of a landscape approach, which brought forward in the discussion paper, is enabled by the Act. It's considered by the Act. It's also something that ministries have been talking about, and in some cases implementing a bit. But we really should be talking about a broad-scale multi-species approach, and this can be very appropriate and in this Act when there are multiple species, for example, sharing similar threats and geographies. To be able to coordinate efforts around them, but also when individual species are wide-ranging themselves and quite sensitive to cumulative impacts. And so this ratchets up the imperative for looking at larger scales and not just the piecemeal approaches that we might take otherwise. And in fact, the Ontario ESOE was designed with provisions for that. It talks about an ecosystem approach, and certainly there is room for a multi-species look at whatever stage of the Act at various times. And we also have to be thinking about the fact that the geographies where there are concentrations of species at risk are well suited for coordinated approaches, and this has been under consideration in many ways for a while. And this illustration is just to show kind of concentrations of federally listed overlapping species at risk ranges. The map just shows Ontario compared to other jurisdictions and where the concentration of species at risk are in Ontario, which suggest that in places where we've got many, many species overlapping together, that a coordinated approach is obviously a very important thing to do and to consider. Similarly, Ontario has already been thinking about a landscape approach for many years. Back in 2009, this woodland caribou conservation plan was issued, and it was actually the ESA's first government response statement. And it acknowledges in there that this species has required a landscape approach, and it's long been recognized. There's even a passage, at least one passage inside, which in the introductory pages talks explicitly about the fact that caribou need to be considered at a landscape scale. This is no surprise to most people, and so the notion of having a landscape approach is welcome. It would be a good thing. It's not easy to do. It's not necessarily going to provide efficiencies with respect to expenses and so forth, but it is absolutely necessary in many cases, particularly when they multiply in number on the list, and also when we've got wide-ranging species that are particularly challenging to conserve. So our recommendations here are first that when you're thinking about responding, please be aware that the tools to deploy a strategic broad-scale approach are already included in the Act, and that's first, and that there would be quite a number of places where a coarse filtered approach should be relevant, but it can't replace species-specific processes. You still need a species-specific lens for assessments or reassessments. How are the species faring? Those are our barometers, as you will. And we need to go back to this individual species to know if they're being well taken care of by whatever provisions are provided. understanding of individual species recovery needs is important to also be able to understand whether or not it is the commonalities with other species and where it occurs and so on. And species are going to be, in many cases, the most appropriate focus for effectiveness monitoring of the Act itself. So the landscape approach is welcome and should be more used, but it can't replace the species specific approaches, and we should have suspicion for any that are put in the name of efficiencies, because that in and of itself will not take care of that. And just finally, that adopting such approach will require deliberate attention to linking planning with decision making, and it's not so simple, and does require quite a bit of coordination at various scales that are meaningful from the species perspective. The second area of focus is on listing processes and protections. And it's interesting that they put these two together because they are in seemingly very different places in the Act, but the listing process triggers the protection. And in fact, what is revealed by the challenge and discussion questions is that the really chief concern is really the automatic protections that get invoked upon listing. And that's what triggers various prohibitions and so forth. But then when that happens, it puts the lens on other parts of the Act, like the trigger itself, for example, whether or not the listing decision itself should be revisited. The assessment process, is the science good enough? Whether those automatic protections are really necessary, or maybe they're happening too quickly upon listing. And so these are the kinds of things that we're seeing in this part of the paper, are those kinds of challenges that are why listing process and protection are considered both together. So our response to that is that, the paper focuses on those kind of visible issues of concern, but it doesn't really pay attention to some of the underlying issues that may be causing these challenges. So it's kind of distracting, listing as a process from or the science of listing and so on, when there are other ways perhaps that implementation might help deal with the challenges. And there are significant improvements that could be made to the assessment process to generate more transparency and trust in the strength of evidence-based decisions. And that is absolutely critical with the science listing mechanism. And finally, we shouldn't exaggerate how many species are coming up. I mean, there are many that have been listed, but there's a lot of work that's been done and many assessments over the years between both the Species at Risk Act federally and Ontario. And so most of the species these days are actually reassessments. So we're more ready than we think for things that are coming down the pipe. And those new species that come up, they're often in trouble for a long period of time before they reach the assessment table. So we should be aware of the fact that there is more. There's more warning signs, if you will, of these species than the day that the listing decision becomes a trigger, and that is important to keep in mind as well. We also want to remind ourselves about the premise behind automatic listing, and this is to avoid spending excessive time and effort on deciding whether a species should be listed, which in effect is the diagnosis, rather than on recovery efforts, which is the treatment. So the recovery efforts, deciding what we're going to do about it, is where the socioeconomic concerns really need to be at the forefront. And we have lots of experience both with the Federal Species at Risk Act now and the previous Ontario ESA, where you had political and socioeconomic considerations come into the listing process. And this results in really significant delays of just even acknowledging whether or not the species is in trouble, i.e. listing it, or no protection at all in some cases. So this is something that we need to keep in mind too. And then the focus on timelines in the discussion paper really is a red herring. By the time species are listed, most of them will have needed protection a while ago. And so revisiting the timelines may postpone some of the difficulties that will come up, but they aren't going to resolve them or make people more ready. And in fact, in some cases, the longer you wait, the more expensive it can come to actually do something about it. So the recommendations that I put forward in this for this part of the paper is that really the challenges that are articulated there really should be addressed by more effective communications with stakeholders and proponents. And the COSARO process is somewhat of a mystery, and there isn't enough communications and so on about what is happening, what's on the docket, what's coming soon, and so on. So we, that the enhancing communications would probably really help many of that situation. And then Ontario must also recognize the difference between concerns about the scientific basis of species status assessments and those about the consequences of the listing. And so those do need to be very clearly separated. And then finally, there are improvements that could be made to the assessment process itself. First of all, one of the issues that I think is important is allowing Ontario government scientists to sit on COSARO, which currently is not allowed. And also to enhance Indigenous knowledge, and these would make some significant differences. And then a more transparent recruitment process, again, more communication, enhanced secretariat support, and then monitoring of recovery effort effectiveness. How well are the species doing so that assessments reassessments are more clear? Are we still good here? Because I'm hearing some beeping, but
I'm trying to figure that out.
Yeah, okay, but I'll just carry on. The third the third area of focus relates to recovery processes and habitat, and this is really where the meat of the action on the ESA is, and so this is where the actual protections happen and where it's most needed. And the following sort of aspects are revealed by the challenges and discussion questions that are listed. The timelines are a real challenge, and that's understandable. There's several required documents, including government response statements and progress reports and so on, that they're done individually for individual species, and similar to the first area of focus, that this is obviously a cause of concern. And second, another aspect that's kind of revealed is that the instrument of habitat regulations, which was originally conceived in the Act, have been largely replaced by general habitat descriptions. And so Ontario is calling into question whether habitat regulations are needed at all. But meanwhile, there's no evidence that's brought forward that we know about how well the general habitat descriptions have been working. There are some key differences between those instruments, which I won't go into, but throwing that out at this point would make no sense when we have no idea how effective we've been in the first place. And this diagram that was put in the Environmental Commissioner's report in 2017 about how authorizations were going is very, very helpful, because it shows kind of the progress and the framework for the different components of the Act. And I want to just draw your attention to the species. We've just talked about the species assessed and classified, but that triggers various other aspects of the Act. But then, oh shoot. But then this is the where quite a lot of attention is being made right now through the planning. Sorry. Through the planning phases, which are done in two stages. One is this recovery strategy or a management plan, which is usually done by a third party, and then the government response statement, which is where the government decides what it will do or not do. And these two, in our experience, are rather, they're done sequentially more than anything. They're not as well coordinated as they could be. And the government response statements tend to be pretty minimal, so very constrained by political and budgetary issues and so on. And this means that there's also a fairly significant focus on authorizations in the regime, and these tend to be disconnected for various reasons. And so the end result is that there isn't much room for meaningful recovery actions. And if we look at the Endangered Species Act in the States that's had like now about a 40-year history. There is good evidence to show that when there is very proactive and strong habitat protection, for example, under critical habitat provisions, that it does make a difference to species. That's where the rubber hits the road. It's not in authorizations, of course. Authorizations are things that are going on that you want to make sure don't interfere as much as possible and can even potentially contribute to the recovery. But that is not where the recovery attention should be. It really has to be on the habitat provisions and so on that come from the recovery strategy and government response statement in that blue box on the right. And so that's where we want to be focusing. And so the recommendations for this part is don't make changes to timelines or on government response statements, but actually focus on how those government response statements themselves can be improved or better aligned or lead to action that will actually provide meaningful recovery potential for species. And so coordinating the process of development of those instruments and again, looking at these with multiple species, and then using the provisions that are currently exist in the ESA, and some of which are really not been used much or tested in any way. And that, and then finally, we also don't think there should be any changes made to the habitat regulations. It would be very premature to do so. It hasn't been used enough to understand how it could be used as it was designed. And we also don't have a good sense about the general habitat description, how well that is doing for species either. And so there's also plenty of room in the Act to delay or not proceed with a habitat regulation, as has already happened many, many times. And so that should provide the flexibility that we have rather than doing that away with that altogether. Finally, in the last section of is devoted to authorization processes. And as I explained, all these are separate, but the undue attention on the authorization processes is of concern, because really where the main meat of this ESA should happen, and based on experience elsewhere, is on habitat regulations and recovery actions and so on. And what is revealed by the challenges that are brought forward in here? Well, there was an exemption regulation in 2013, which was quite substantive, and it introduced this permit by rule system. And it seems then the implication is that Ontario is still receiving complaints that development approvals are being held back by species at risk considerations. It's still not streamlined enough, which is a cause of concern. The province is also considering a habitat banking approach. No description, but we're interpreting it as sort of a potential pay-to-play system. So, have proponents pay into a bank rather than, undertake activity-based requirements, and that in lieu of activity-based requirements is explicit in the discussion question. And the province is really in this section seeking other ways to enable an economic development, kind of in spite of the ESA, without revoking it altogether. And that's the best way of interpreting that section. And this overall benefit figure, which is a little bit fuzzy when it's blown up, shows kind of how the whole act was put into place. That when it came to permitting activity that was going to have the potential to harm species, the notion was not to bank on kind of minimizing adverse effects, which is really the business as usual approach, sort of make it less bad than it would otherwise be, but actually seek to benefit, sort of the net gain, or, one step up from no net loss notion. And in fact, the Act was, put forward with that in there. But then what happened with the exemption regulation in 2013 for a number of activities is that it ratcheted down the standard again back down to minimization of, do not harm, so minimization of adverse effects rather than overall benefit. And that is a significant change. And we don't really know the effects of that change. We don't know We don't know how the species have fared during this, and we also don't know whether or not this has improved the permitting process. But some data suggest that there have been a significant number of increased authorizations. The ECO did a really good look into this and understanding, because this is not known to the public, but how you could how many registrations and permits had been issued, and certainly the 2013 line does show a distinct difference, which suggests that these permits are given with more ease at that time. But they also made careful to make the point that you have to, if you're going to move to such a system, sort of this permit by rule system, you need to also include a robust inspection, compliance, and enforcement system. That is absolutely critical, so that you can, check and see whether or not the implementation measures are actually working, how are the species faring, and so on. And the ECO in 2017 did conclude that this was not occurring. So although authorizations were increasing quite significantly, we didn't really know what the effects of that were. So our recommendations is really when you're improving the implementation, it's got to be done in tandem with the other provisions of the Act. So the recovery, the taking care of habitat, and so forth. And so the habitat protection measures need to be effective themselves and simultaneously improve outcomes for all species. And then if a more strategic approach can be developed, and perhaps that is implied by the landscape approach in the first section, this will help with authorizations, because there could be much more proactive consideration of species needs into provincial processes that are existing at the appropriate scales, including land use planning, cumulative effects assessments, and even other fundamental decisions like annual allowable cut and so forth, that could happen earlier in the process and more strategically, rather than sort of out by itself in a kind of a permitting situation. And then also, really all evidence suggests that, or really points to the fact that the earlier that needs of species can be addressed in development activities, the less expensive it is, and the more efficient it can be. And so, how can the process be developed so that authorization occurs really early and at appropriate scales? And then we have to understand that the more the condition of a species deteriorates and meaningful protection is deferred, the more expensive it gets and more complicated it gets, and it actually gets more expensive. It actually makes the job much harder, and there's lots of evidence of that too. So I'll conclude with just a few thoughts, that I come away with from reading the paper, is that, just to remind ourselves that the Act was put in place in 2007 to improve an existing situation. I mean, there were elevated species at risk lists, and there was definitely sense and abundant evidence to point to the fact that the species at risk, once they reached that point, really needed extra sets of protections, because existing policies were not taking care of them effectively. But the discussion paper really seems to make clear a heavy focus on finding new ways to expedite economic development, albeit without repealing the Act itself. So how can we make this work so that we can, enable these activities, which kind of misses the point in some ways. And there is no indication, the discussion paper, although it may exist elsewhere, in the 7 pages, where is the analysis that comes up to where are the challenges coming from, and what are the underlying reasons for those challenges? What are at the root of complaints, and how well is the system working now for species at risk themselves? Not in terms of just meeting all the timelines and process-oriented things, but how are the species themselves doing? The discussion paper also seems to take it as a given that any economic development will actually be able to benefit species at risk, and that's just simply not the case. This Act does make it clear that there in some cases will be trade-offs, and it does allow for socioeconomic considerations to prevail in those trade-offs, but if the decision is made in a transparent manner. But by and large, these need to be confronted through the framework that has been devised in this Act. And developing fixes without really understanding the problem is not where we want to go. And so I think with that, I'll pass it over to Rachel. Thank you so much.
I'm going to walk you through some things that you can do. And the first, as we've discussed, is to respond to the discussion paper for which comments are due on March 4th. So the website address is up here, and you have to put in under the search those 7 numbers. And then you should see this page. So we just included this screenshot so that it looks familiar to you. And we know that the webinar, for some of you, it was perfect. You're totally in the weeds and you have an interest in the minutia and all of the different policy angles. And for some of you, maybe that level of detail of policy is a bit overwhelming. So we wanted to reinforce the main points. The main points are that it's not the structure of the ESA that's broken. It doesn't need to be amended. What needs to change is that it needs to be better implemented. And the second main point is that species at risk across Ontario, across Canada, and across the world are at risk primarily because of habitat loss and degradation. And that in Ontario, especially if you look at the map that Justina showed that showed the overlap of species, is because of development and industrial activity in their habitat. And what is needed is better habitat protection. And definitely what's not needed is to make things easier for industry to operate in the habitat of species at risk. And also, as Justina mentioned, if the Act's implementation is going to be improved upon, the most important thing that needs to happen is to repeal the broad exemptions that were granted for industries like the logging industry, which basically doesn't have to abide by the prohibitions in the Act. So you can do the discussion paper in your own words, but we do have a guide that, if you would like, Anne has developed a concise guide in collaboration with some input, some other colleagues, and our email addresses will be included on the last slide. And if you're interested in the guide for responding to the discussion paper, then you can email Anne. So here are some other things that you can do. You can share information about the ESA and the threats to the ESA through social media, through Twitter, through Facebook. The David Suzuki Foundation has a social media kit that's available. The way you access it is by doing our action alert. So that's on our action page of our website. And then once you do the action alert it'll say thank you, and then it'll say if you want to do more things, here's access to a social media kit. And it just has a number of images that you can use, that you can plug in to use for Twitter or Facebook. We need the word to be spread. It's not everyone knows that there is a threat to the Endangered Species Act, and I think most people do care about wildlife in the province, so it's just a matter of getting the word out. So please tell everyone you know that you think will care about this issue. You can point them to our 3 organizations, all have information about it on our websites, and action alerts that our action alerts have a preset template for you to fill in that will go to your MPP and to the environmental registry comment section if you don't have time to respond to the discussion paper on your own. One of the most important things to do for sure is to reach out to MPPs, your local MPPs, especially as that varies regionally across the province. And you can do that in a number of ways. If you're pressed for time, you can do a phone call and just say that the discussion paper, that you've looked at it, that you've heard a bit about it, and that it causes you alarm, that species at risk are something that you care greatly about, and you'd like to hear what your MPP is doing to protect them. You can send a letter. If you do, it's great if you can CC one of us on it so that we can know who to follow up on. And obviously, best case is that you can request a meeting. You can develop a personal relationship with your MPP and hold them accountable. Lay out your concerns and then request a follow-up for how they're addressing them. Another thing that you can do is write a letter to the editor of your local paper. And again, if you would like a template for how to best do so, you can contact one of us. Most of our organizations have templates for doing that. You know, we recognize that this is a despairing issue, that it's to some extent an despairing climate right now. And one of the things that we're trying our best to do is to find ways of using humor to address that. And to that end, the David Suzuki Foundation is releasing a satire about this problem. And if you follow us on Twitter, that is going out later this afternoon, or it'll be available on our DSF website under the Species at Risk page. And I really encourage people to send that around, because I think what we really need is a way to laugh about it and look at the issue with humor. We all get a little bit of fatigue about the environmental crisis that we're collectively addressing. This comment period isn't the end of the process. The next step will be for the province of Ontario to post the proposed amendments, should they have any, on the environmental registry. And then once again, you can look to our organizations to see how we propose to respond to those proposed amendments. And I think our organizations are also, you know, continually looking at what are the best creative ways to continue our efforts to protect wildlife. And we want to say collectively that your voices truly do matter. And we probably can't stress that enough. Your voices, the voices of your friends and family and your colleagues. What we need to do is let the province know that collectively we care about wildlife, and we care particularly about the recovery and protection of wildlife that is at risk. And one example recently of where our voices was heard was the significant outcry against the proposed Bill 66 that the province ended up listening to the people on. So here, this is our last slide. It has all of our contact information. That's Anne, Justina, and myself, Rachel. It has all of our Twitter information if you'd like to follow our organizations on Twitter. And we are now going to turn it over to a question and answer period that will be moderated by John Hassel of Ontario Nature.
Thanks, Rachel. So we've had quite a number of questions we'd actually love to see about what can we do, how can we engage on this issue further. So I think a lot of those came in just before your presentation. So I think you've addressed most of the sort of follow-up steps. So unless maybe re-ask the question if there's still confusion, but I think you kind of addressed a lot of that.
And I have been working on this for a long time. One of the things that I find the most fruitful is to brainstorm, because I think, you know, there's mechanisms that we continually use like consultation periods, but what I propose is getting together with the people that you know that care about it and say, are there any unique things that we could do? I know once when I was campaigning for the spotted owl in British Columbia, we ordered owl kites, and we flew those kites on Parliament Hill every day, and we created a banner that said, at the time, Ron Ambrose, you hold the strings, the fate of the spotted owl is in your hands. So just try to do something that makes you feel excited about getting the word out.
That's great. I like that one.
And I just wanted to just add one thing, is that this is tricky because it's the most members of the public will be satisfied if they know that there is an Endangered Species Act in place, and won't be so aware of any weakening that occurs behind the scenes. And certainly that happened in 2013. So being aware of some of these minutiae that we did talk about today is a good thing, because there is a difference between you know, a robust act and one that's implemented, and also, you know, pay attention to some of the changes that might be coming forward. And it's at that time that we may need the public's attention, who will say, hey, wait, it's not enough to just have an Endangered Species Act in place. We actually want one that's effective.
Okay, another question that came in, is there nothing in this discussion paper that you would support?
Hi there, it's Anne. I can take this question. And quite frankly, there's nothing in terms of the changes to the ESA in the discussion paper that I would support. The improvements needed all have to do with implementation. Landscape level planning, for instance, could be very beneficial for wide-ranging species, as Justina explained, and the ESA already enables that. So the question really is whether the government is willing to put the resources into implementation.
Thanks, Anne. We've got another question. Why are Ontario government scientists not allowed to be on COSERO?
Well, let
Yeah,
Justina
yeah, I mean, so let me, at the beginning, Ontario government scientists were on COSERO, and then a decision was made not for that to happen after a few years of implementation. And the reason that I've been told is, an interest in having those assessments be entirely independent from the implementation agency. So that's the same for the recovery strategies. The recovery strategies are scientific documents that are done for the most part by third party, and that is something that was decided fairly early on into the implementation of the process. The one thing I will say is that the independence needs to be there for every member of COSERO. For any member of COSERO might have a conflict of interest in one way or the other, they have to be able to deal with those in a forthright fashion, and there are ways to do so with strong terms of reference, strong chair, and so forth. Ontario government scientists often have the most knowledge about species at risk in the province, and disconnecting them from being members of the committee it has its costs. It also has its costs with respect to so it has its costs, and so that's all I want to say about that at the moment. Sorry, I could say a few other things, but I'll leave it at that.
And John, I just want to add in here that I'm going to sound like a broken record, but this is not a fault with the law, it's a fault with implementation.
Yeah.
The law doesn't need to be changed to address it.
Thanks. Okay. With respect to the landscape approach, would the set regulations approach be problematic to private landowners?
Can you repeat the question, John, please?
So I'll read it exactly. So my question is, with the landscape approach, would the set regulations approach be problematic to private landowners?
You mean the landscape approach itself? Would that be problematic? Is that what?
I suspect that's what the person's getting at. I'm not positive.
Yeah. I mean, that's a good opportunity to talk about the fact that the Act also has room for stewardship investment, and indeed there are also lots of examples in the states of significant stewardship activities like safe harbor and so on that are starting to come into play in Ontario, but could be used more and will require investment on private lands in particular. And you can imagine ways in which the landscape approach, it would require significant coordination, and certainly in southern Ontario where there's so much different land ownership and so forth, it would be very, very challenging. But it is absolute, some kind of coordination is needed, and there have been some examples of that in areas of Canada, for example, grasslands and so on, where and some places in Ontario as well, where that has been able to occur. So we'll have to look at those models.
Okay. There's another question about why would ministerial discretion about the listings be a bad thing?
So I can take that one, John. In a nutshell, ministerial discretion is about politicizing the process. It's about politicizing those aspects of the law which, quite frankly, I think should just be givens. Species listings based on science and automatic protection of a species that's threatened or endangered and its habitat. We've already had experience in Ontario with political listing process, and that was under the old ESA. The old ESA had a legal list, and it had it had the science list and had the legal list. And the legal list was the list of species protected under the law. And at that time, many of the species that were endangered weren't protected under the law because there was a political decision that it would be, for one reason or another, not acceptable to protect their habitat, protect the species. So when the efforts were underway to revise the Act in the lead up to 2007, advice to the government from lawyers and from scientists and from others, conservationists, people concurred around the notion that this needs to be a science-based process at the start. The listing process and the automatic protections need to be science-based. And then the loosening up of considerations for socioeconomic reasons can follow after that. And I think one of the things that we need to remember too is that as soon as you start to politicize a process, then you introduce a great deal of uncertainty. And the government loves to tell us about how it's trying to make a clearer act and offer more certainty, but ministerial discretion goes in exactly the opposite direction because it will, give rise to controversies about whether species should be listed or not, whether they should be protected or not, resulting in delays and so on.
Okay, that's great. There's a question here about the presentation will be available after the answers. So yes, we've recorded this webinar and we will be circulating that to everybody. Here's a good one. So do you have any suggestions as to how we can best present the need for added resources to improve implementation, given the political focus on cost cutting?
It's Rachel. I think I'll take that question at the broad level, and I think that is that government responds to what they see as the priorities of their constituents. So while sometimes conservationists do more focused things, like we actually make budget recommendations, we do that at the federal level collectively. I think in this instance, if there can be a groundswell of people who collectively say wildlife and the protection of wildlife and the protection of species at risk is a priority for us, then one way that government responds is by ensuring that they have the resources to address the need to safeguard wildlife and species at risk.
And I'll add two things to that. One is that there's lots of evidence to show that the earlier species at risk considerations are brought in planning stages of development and so on, the less expensive it can be. So it's much harder to rearrange plans and more expensive and so on later on in the process. And secondly, the more proactive we can be about taking care of the needs of species at risk, the less expensive it will be later when things really, after species have deteriorated. So it really just, there are a variety of reasons why it makes sense to invest at this point and not let it go for later.
Okay, we've still got a few more minutes. So I'm just going to keep going with the questions. Here's one. So what's the relation between this act and decisions made by the Niagara Escarpment Commission on species at risk? So if this is one we need to follow up, we will be following up with questions that are unanswered later. So this could fall into that category, or maybe we have a quick answer now.
I know, John, that under the Greenbelt Plan and under the provincial policy statement, I'm pretty sure that they defer to the ESA. So, but I'm not sure with the Niagara Escarpment if that's the case.
Okay, why don't we follow up with that one after? Here's a question. So you note that the MNRF was interested in a landscape approach some years ago, though the term is not defined in this recent government report. Was the term more fleshed out by the MNRF at the time? If so, how was it received?
Yeah, I guess that's for me. That's difficult to explain in a short period of time. It wasn't. It did precede a structural transformation in the ministry, but it's very difficult to know what the consequences of that have been, particularly for species at risk, because with many things we don't really know, and how and how the structure actually attached to decision making on the ground is somewhat elusive. For some species that I know that demand a landscape approach, there wasn't a significant difference. And the other point is harkening back to what Anne said at the beginning, that the species, this ESA is now going to be administered by a different ministry. So what that looks like and how a landscape approach would be implemented in that context is really unclear at this point. So we'll just have to watch out for that.
Okay. To your knowledge, are requests through freedom of information on projects affecting species at risk being slowed down due to this review?
I don't know.
I'm not sure. They're very slow anyway. This is a difficult way to get information, and one has to be quite precise, and it can take very, very long time. That's one of the reasons why the Environmental Commissioner of Ontario reports on species at risk since the passage of the Act, and there have been either several devoted chapters or complete reports to the implementation of the Act, where the ECO has been able to get information that members of the public don't really have access to in a much, it's been a very effective manner in terms of being able to see some of the consequences of the streamlining that decisions and the regulation in 2013 and in other places as well. So that's just just to remind people about how important the ECO is in that context.
Thanks. And maybe we've got time for one final question. So in addition to posing the potential changes that may stem from this discussion paper, are there improvements that you would suggest the ESA within the context of the discussion-based paper or beyond the focus of the paper?
I think that one of the main messages that we're trying to relay is that the improvements need to be focused on improved implementation. When the Act was passed, it was lauded as a gold standard Act. It really has, the architecture is very sound. It just needs the political will to be implemented. And as Justina mentioned, that means that looking at, sometimes it might not be appropriate for activities to happen where in the habitat that species at risk need to survive and recover. The one thing that we do need to see is we do need to see the broad industrial exemptions repealed. And so that's part of the message that we're going to be pushing as well.
Okay, so thanks everyone. I think that wraps up our time. If you have any sort of follow-up, as you see on this slide right now, there's contacts for the three presenters, and we'd be happy to hear from you. And we will be sending an email to everybody who attended with more details and a link to watch the webinar.
Thanks very much for joining us.
Thanks, everybody.